Thanks for joining us. Last session of the day. We're really excited to be here with you all.
Is everyone very excited to hear about court communications? Yay!
All right, we might have a few more people trickle in, but we'll go ahead and jump in. All right, so like Isabel said, today we're going to talk about missed court appearances, also known as failure to appear, and the impact they have on your courts. And we're going to talk about court reminders and how they're a very effective tool to increase court appearance. We'll dig into the details of how you can set up an effective court reminder system, and then we'll save time for the best part, which is all of your questions. All right, I'm still learning how to use this clicker. All right, so we're going to all briefly introduce ourselves. I'm Ann Stotler. I work for a nonprofit called Ideas 42, and specifically for our Unwarranted initiative. We've been working for almost 10 years to reduce missed court dates and all the negative impacts that flow from them. So we do that by working with courts all over the country to improve communication about court dates, including helping courts set up court reminder programs. And I will pass it to Marshall.
To me?
Yes.
My name is Marshall Dixon, and I would first like to welcome all of you to my wonderful city. Yay! And if you need recommendations for margaritas later, come talk to me. I'm a statewide program manager with the New Mexico Administrative Office of the Courts. I help implement pretrial service agencies throughout the state. We have one last judicial district to do. It's 3 counties in the southeast corner of New Mexico. So we should have that knocked out by the end of the year. But I also run the text messaging program for all the pretrial clients that we send messages to. And we'll send it over to Isabel.
Hello, I'm Isabel Shapiro. I'm with the Pew Charitable Trust Courts and Communities Project. For those who haven't worked with us before, we do work with state partners like yourselves across the country to expeditiously resolve cases, to mitigate collateral consequences of folks moving through court, and to implement different types of policies, especially in high volume case types. We produce original research, we uplift champions, and we do a lot of technical assistance work. Right now, we're continuing work that we've done for a long time on missed appearances, and specifically we're focusing on legislative solutions and implementing statewide text message reminder programs. So if anybody wants to talk more about legislative stuff after this, please come and find me or ask a question during the Q&A. I'm also your opening act. Thank you. If there's one thing that I hope that you guys get from this presentation, at least my small portion of it today, it's that folks miss court for all the same reasons that folks miss any kind of appointment, right? Yet while so many other industries, especially in like the medical field, my dentist will not leave me alone. They'll probably text me during this presentation. While other folks have really leaned heavily into modern forms of communication and text message reminders, courts tend to still focus primarily on a reactive approach that follows up to missed appearances after the fact, even though it hasn't necessarily proven to be a cost-effective way to reduce missed appearances. And what's more is that we actually know what is effective, and that's effective, well-designed court communications and text messages, which we know from a whole slew of evidence really works well. So to kick us off, before Ann and Marshall get into the really good nuts and bolts bits, I'm just gonna set us up with a couple things. We're gonna talk about how often folks miss court, why they miss court, and why it really matters. So we're gonna start with how often people miss court. This is actually a much harder question to answer than it seems. Do folks here know what their missed appearance rates are in their jurisdiction? Raise your hand, shout them out. Marshall knows. Yeah, I'm not seeing a lot of hands. And it's hard to track, right? It's hard to collect the data. And not a lot of places do it consistently across jurisdictions. Another thing that makes it hard to track is that there are a lot of factors that influence missed appearance rates. So we're gonna start by talking about geography. These are 7 studies that look at missed appearance rate in different places. You can see all the places lined up here. You can see the authors of the study and the year they were produced. And it's a huge range, right? It goes from 12% to 53% of cases. And that 52% of cases is a very large number, but 12% is nothing to sneeze at either, especially in a populous area where that's a lot of cases. That's a big chunk of people who are not showing up to court. And it makes sense in some of those places. You would assume there's a similar legal framework, there are similar policies at play, but even within the confines of one particular state, there are very large differences in missed appearance rates. This is from a project that our team did in North Carolina in 2021, and it looks at missed appearance rates by county. And in the darker blue areas, there are higher missed appearance rates. In lighter blue, it's fewer. On the fewer side of the range, we've got Orange County, which is a much more affluent county in North Carolina. We've got Robeson County down here in the south center area, which is a much more impoverished rural community. But again, even in some of those places that have more money, have more infrastructure, have better transit, you've still got 7% of folks who are missing cases. There's still a lot of places to improve. It's not necessarily urban versus rural or impoverished versus affluent. This is a problem across a lot of different places. And even under similar policy structures, there's a lot of variance. So, second thing I'm going to talk about is actually even within courts themselves, in jurisdictions. Another factor that influences missed appearance is case type. So we see that the most missed appearances happen in traffic, misdemeanor, and misdemeanor cases. This is important for two reasons. One, these are extremely common case types, period. So they're dragging missed appearance rates up if we're not effectively addressing missed appearances in traffic and misdemeanor cases. The second thing is that this starts to undermine some assumptions that some folks have that folks, when they miss court, are absconding or evading legal consequences, because certainly there are consequences that come with traffic. But this starts to paint a picture that we're going to get further into and paint out some of the details of, which is that the folks who miss court are folks with pretty average court cases. They tend to be everyday folks who are facing everyday obstacles. So another factor is in who is missing court is demographic. This is from a public poll that our team fielded in 2025, and we asked folks, have you ever missed court? And about 19% of folks who responded to the poll said that they had missed court. And these are those folks broken out by demographic. And you can see that pretty even split across political party, across gender. Where you see some differences is in education, income, and age. Folks who have a lower level of education, who have lower income, and who are younger tend to be more likely to report having missed court in the past. And again, this is important for a couple different reasons. One, beginning to see a trend here, these are folks who are overrepresented in our court system, period. Secondly, it starts to call into question some real issues of fairness and equity. If the folks who are in more vulnerable population groups are the folks who are having less access to the justice system and missing court more frequently. So this brings up one of the crucial questions today. Why do people miss court? And while we're talking about this, I would love for everybody here to call to mind the last time you missed an appointment for anything. Or if you had to reschedule, but you would have missed it if you hadn't been able to reschedule, because that's very much not an option in many cases when it comes to court, right? I want to bet that the reason that you're thinking of, we're going to discuss in the next couple slides. Would put money on it. If anybody wants to do that, raise your hand. I got some cash out earlier for the coffee. We can do that. The first few things we're going to talk about are just, this is a non-exhaustive list, but again, these are just everyday obstacles that folks face when it comes to missing court, and this is based on a lot of evidence and talking to a lot of folks who have missed court. Life challenges, housing instability, behavioral health issues, logistical issues. We've mentioned transportation, inflexible work schedules, not being able to find childcare. I know some folks, some courts are much more welcoming of having children come into the court, but folks don't always know that they can bring their kid with them or that there are other available options to them, and it can be very hard to figure out. Even for virtual court, logistical issues can get in the way if folks don't know the link, if they don't have technological access to something, if they're in an area with limited broadband. those are all reasons that are very common across all types of appointments, all types of obligations. One that is slightly more central to courts, that doesn't show up quite as much in other places, but is certainly not exclusively a courts issue, are behavioral barriers. So people are often very confused about how to meaningfully engage with their case. And sometimes that involves how to show up for their appearance, where they're supposed to go, when they're supposed to go, when their presence is required. I think we all know that court forms and information is often written by and for lawyers, or at the very least, folks who are very regularly using terms that don't necessarily show up in everybody's everyday vocabulary, like show cause or capias. Any other suggestions from the audience, some terms that come up frequently? No, not at 4 o'clock in the afternoon. We're not really excited about audience participation. That's okay. One last behavioral barrier, though, is that folks often have traumatic experiences associated with courts or law enforcement that they have maybe experienced themselves, or that a member of their community, a member of their family, their friends have had, that make them less likely to trust that if they do go to court, they will be treated fairly. And that is important when we talk about missed appearances, because a few different studies, including the poll that I've already mentioned, demonstrate that when people trust courts less, when people feel like they will not be treated fairly, they are more likely to report having missed court. They are more likely to miss court. So trust is a big factor that is very specific to courts. I have not mentioned one of the absolute most important reasons why folks miss court. Does anybody want to shout out what it is? I'm going to keep asking for it. They forgot. People forget. Honestly, I should have mentioned the prizes. Maybe we would have gotten some more conversation going earlier. So this information on the screen here is from the same poll that our team did in 2025. When we asked folks if they had ever missed court, and they said yes, we asked them why. Why did you miss court? And overwhelmingly, the number one reason was that they simply forgot. This is something that we all deal with. When folks were thinking about the last appointment that they missed, how many folks just forgot? A lot. That is a big reason why we all miss things. And we often rely on those text message reminders that we get from other types of industries. I would never make it to a hair appointment if they weren't texting me in advance. I do want to call attention before we move on to a couple other things on here. 2 other reasons. Didn't receive notice or updates, or the information was confusing. If you combine those with forgot about the hearing, you've got 50% of all of the folks who reported having missed court. All of those reasons are directly responsive to clear, well-designed court communications. So there's a lot of evidence to suggest that by improving court communications, you can do a lot on the front end to prevent missed appearances. Before we get more into that solution, though, we're going to talk about why this matters. And I know that folks in this room are very familiar with these things, and so we won't belabor it. But I'm going to talk about the implications for the individuals, and in a little bit is going to talk about how costly missed appearances are for the courts themselves and for the justice systems. But real quick, just to talk about, go back to some of the trust issues and the idea of proportionality as it relates to the rule of law. Most states, as you all know, have some combination of bench warrants, suspending driver's licenses, and new charges as responses for missed appearances. Whatever form those take, some states don't necessarily suspend driver's licenses anymore. The bench warrants may be called something else. They may be dealt with in a slightly different way. But what's important is that the upshot of all of these is that they create pathways to jail that would not otherwise be on the table for most people who have missed court. And we'll get more into that in a second. But it's borne out by the data. This is data from 2 different studies, one in Louisville, one in St. Louis. And it's showing arrest data. In the dark blue, you've got arrests for bench warrants alone. It does also include out-of-county fugitive warrants, but those were such a small part of the data that it's virtually exclusively bench warrants. In the light blue, you've got bench warrants plus another charge. But we don't know to what extent those additional charges were also stemming from the same missed appearance that caused the bench warrant. But even so, if we're just talking about the dark blue, in Louisville, you've got about 1/5 of all arrests coming from missed appearances in 2019. In St. Louis, over 1/3 of all arrests coming from missed appearances. This is a lot. This is also very consistent with projects that we've done in other places. So we found similar findings when we worked in Michigan in 2021, 2019. Around there, we found similar things in North Carolina in 2021. And most recently, we did a data analysis for the Commonwealth of Virginia. We found that missed appearances were the #1 reason for custodial arrests in 2023. This is a persistent trend that they're causing a lot of arrests and a big share of arrests. It's like really has a huge impact on the local justice system. Furthermore, looking closely at that study from St. Louis, when the researchers looked at those warrants and the underlying charges, they found that 2/3 of them were for ordinance violations. So cases that would have never had jail on the table were it not for the missed appearance. 2/3 of 1/3 of all arrests means about 22% of all arrests in 2019 in St. Louis ultimately came from a charge that was something like driving without insurance, driving without a license, or driving with a suspended license, which are all very serious things, but our justice system does not typically assign jail as a punishment for any of those things. So missed appearances are really inflating arrests and jail admissions in a lot of different places, which is expensive for the justice system. Also, we know that even a minimal amount of time spent in jail can completely derail a person's life, especially someone who's really just holding it together. If they're one of those young people, if there's one of those folks who are low income, this is a serious problem that is disruptive to society and communities at large. The good news is that we kind of know what works, and it's not actually arresting a lot of people. Text message reminders have been shown time and time again through randomized control trials, which are the gold standard among research methods, that they can reduce missed appearances by up to 39%, which is a huge margin for any policy, right? That is like unheard of effectiveness in public policy. And I just want to point out that RCT number 3 was done by our friends at Ideas 42, and Anne will talk a little bit more about that specific number. But this is really consistent across a lot of rigorous research studies. And it makes sense because of all of the things that we've already talked about. Text message communications is modern communication. Text messages are easy to read, easy to access, easy to store, easy to search. So it means that somebody's court information is traveling with them and always available to them on their phone. And so it makes sense when in the public poll that I have mentioned a couple times today, when we asked if folks supported courts sending text message reminders, the vast majority of people said that they were comfortable with it. And more than half of people, well more than half of people felt positively about it. Again, these are unheard of favorability numbers for public policy. Nothing gets this type of favorability rating. But of course, we're all very used to receiving text messages. Even so, text messages tend to be underused in courts across the country. About 10 states have no text message reminder system at all. This is based on a 2025 survey that we did, a 50-state survey. So there are some changes to this map in the past year or so. 10 states have no text message reminders at the state level. 19 provide text messages in some jurisdictions, and 18 states have statewide text message reminder systems for court. Even among those 18, though, there's still a lot of space for improvement in a lot of ways. And I'm just setting up my friends Ann and Marshall here to talk more about what makes a court communications program really especially successful. But in general, the idea is that there are a lot of benefits being left on the table, and there are a lot of ways for every single state up here on the map that includes all of the states to improve how they communicate with court users. So with that, I'm going to pass it off to the stars, the headliners of the show. Ann's going to talk a little bit more about the actual dollar amount that missed appearances are costing courts, and Marshall's going to talk about his experiences in New Mexico.
All right. So, as Isabel shared, text reminders are a really impactful solution to missed court dates, but they're underused. So I just want to kind of underline why that's such a huge missed opportunity for courts by putting some numbers on it. So every missed court date drains money, resources, staff time from everyone involved. So we conservatively estimate that each missed court date costs the government $1,500. So that includes cost to courts, but also to law enforcement, to jails. Everyone is kind of negatively impacted by this. But specifically looking at cost to courts, this involves a lot of court staff time. So time spent preparing for hearings that are missed, time spent rescheduling hearings, time spent issuing warrants and suspending driver's licenses. It also affects your case flow. So you have dockets that are clogged with unresolved cases. You have staff having to do repetitive tasks. Curious for a little audience participation here, if anyone else wants to shout out any other consequences you've seen in your day-to-day work from missed court appearances. Anyone? Anything I missed?
There are prizes on the table. For anyone who didn't hear, she said the frustration to judges because judges have to stop what they're doing to try to figure out what's happening with the missed appearance.
I think on future bail decisions, because bail is decided on whether you missed previous court appearances. So once you start missing them, that's going to make it that much more likely that you're going to be held on bail and not just released on your own narcotics.
Impact on future bail decisions, for sure.
Risk assessments. Oh.
Pretrial
justice ears burn.
Trial certainty. So if there's a trial date on the horizon and somebody doesn't show up, that's a trial date that someone else could have gotten because unless the state's going to get attention, it's just a giant waste of time.
Trial certainty. Thank you.
I would also say cost of interpreters. You know, you booked an interpreter, they need whatever the interpreter is, and then they bear the brunt of that cost because the interpreter is there for the individual who fails to appear.
Cost of interpreter. I'm just repeating for the recording now. You guys are very clear.
Anyone else? Anyone else? Going once, going twice? All right, great. So you all mentioned a bunch of different ways that this impacts you. Just to dig into the financial aspect a little bit more, I want to show you a little bit how the costs can add up. So let's say you have 25,000 missed hearings every year. Some of you mentioned you don't know your missed court date rate, so maybe you don't know, maybe you do, whether this is like a good number for your court. But for the sake of the example, we'll say 25,000 missed hearings. That will cost the government almost $40 million. Once you take that 1,500 number and you multiply it, right? But if you have an effective reminder system in place, you can take a huge chunk out of that cost and that impact. So we're going to use the 26% number. Isabel mentioned that comes from our study, but other studies have shown even higher impact. But if you take 26%, that's 6,500 more hearings that are attended. That saves the court almost $10 million. And I should say that's the government as a whole, not just courts. So setting up a reminder system does come with some costs, which we'll talk about, but the cost of missed court dates is so much higher. So the return on investment here is huge. And I'm sure you all have a huge wish list of what you could do with that money that you save. So every dollar that isn't spent on missed court dates can be reinvested somewhere else in the system. All right, so now I'm going to hand it over to Marshall to tell us about what this looks like in his court. courts?
Sure. So in 2014, through the great work of a Supreme Court justice, a wonderful court administrator, an excellent court case, an amendment to the state constitution, we really started ramping up bail reform in New Mexico. A piece of that was also aligning with the National Institute of Corrections and the National Association of Pretrial Agencies. At that point, we found that we needed to track two outcomes: public safety and failure to appear or appearance. Once we had those, we already knew that, like, if we called somebody, they were more likely to show up to court. And so I had a bunch of officers, while I was running a pretrial services agency, calling a bunch of defendants. Sometimes they get a hold of them, sometimes they wouldn't. Sometimes we get a hold of mom or dad, sometimes we get a hold of a friend. And we knew that the further we got out from contacting that person individually would be a decrease to their appearance, right? So we were focused on increasing those rates. So we began text messaging through email. You can still do that. It's not effective and definitely not efficient. But we wanted to make it easier to get to court. And so we partnered with a private vendor, eCourt Date, in order to automate text messages. So I was able to really move that ball forward by getting pertinent information to cell phones when that person's available, right? Because we know, like, I've been called a couple of times just in conferences today, couldn't answer that call. Again, medical appointments. And so we knew that if we could increase the messaging and get that message to those people timely, we would see an increase in court appearance. So today, our focus is on those court text messaging. We have two systems in New Mexico. Every criminal defendant in New Mexico gets text messages automated through the court system. And we'll talk about what that DIY system looks like later. And then every pretrial services client gets not only court hearing reminders, but we also set them up with court cancellation. If they miss court, we come back to them and we say, hey, you missed court. Get a hold of us. Let's get you back into compliance. And any number of other messages, also to support remote reporting and office visits. So we want to keep people in compliance. So we have a lot more involvement and engagement with the criminal defendants referred to pretrial service agencies throughout the state. Currently, we have about 75% participation for those that are referred to pretrial programs. In the next two graphs, you can see about half provide us with a phone number and about half provide us with an email. In calendar year 25, we sent like 365,000 messages for about 90,000 hearings. The statewide program, they doubled up on us, but they're sending to everybody. So people coming to pretrial generally aren't your traffic court folks. And so there's going to be kind of a disparity there as well. So let's talk about the numbers. We know that pretrial clients do really well and appear to court probably more often than just your average person, right? Because they're involved with adult supervision. So we're sitting there at almost a 90% appearance rate for people not receiving reminders. There's only about a 3 to 4% difference between not receiving reminders and receiving reminders. But what does that mean? For those that received reminders, it's about, like I said, it's about 3 to 4%, but that's about 2,800 court dates. And what Ann told us is that court dates cost about $2,800. So it's about $8 million savings right there for the court, when our court contracts just a couple tens of thousands. So court hearing reminders, super effective, super high return on investment. Oh, do I have more? Okay, sorry, I forgot. We got to messaging. So all of our messages try to move back to the pretrial programs. So all of our engagement comes back to the pretrial program. We didn't want to put any more burden on the court than what we do. So we get return messages all the time of like, okay, thanks, I'll see you at court. We get messages like, I'll be there at 1:30. Good morning, yes, sure. I will go to court. Thank you for reminding me. And then we also find out that people have issues in their lives. My car broke down. I'm not going to be there. Help. I didn't make it for my appointment today. I missed the bus. Like typical stuff. Yes.
So I believe this works to get people to court more often. Great. But we talk cost savings. For us, it really means if your time disposition down, your disposition rate up. If you look at that, to kind of see that the end result is
That, if you're moving cases faster, okay, now we're starting to get your backlog and all that's going to drop down. So, just a question.
Don't have the answer to that, but I can work at finding it for you. That's a great question. I will do you one better. I will get you a notebook. No, that's a solid point. Again, I'm just a pretrial guy, so I don't look at the overall court disposition stuff, but that's a great point, and I will make sure to have an answer to that the next time I give this presentation.
Got to come back for more.
Okay, for now. For now.
Hopefully we've convinced you that reminders are a good idea. But now let's talk about what it takes to actually build a really effective reminder program. So first, it starts with embracing a new way of thinking and maybe challenging some traditional assumptions that we might hold, as Isabel kind of touched on. So traditional assumption we sometimes hear from courts. Court's really important, right? People know that, they should know that. So if they're missing court, then they must not be taking it seriously. But we know that there are a lot of barriers that get in the way. Again, if people are missing court, they must not be paying attention, they must be irresponsible. But we ask, is the information that's being provided to them being communicated clearly? And finally, some folks think that increasing penalties for non-appearance will kind of scare people into going to court. But we've actually seen that when people are afraid or they're uncertain, they don't know what's going to happen to them when they walk into that courtroom, they might avoid court, even if they know what the consequences are. So understanding all of these drivers helps us to know what the underlying problem is, and then we can identify solutions that actually address those problems, like court reminders. All right, so as Isabel shared, there's a lot of evidence showing reminders are effective, but you can't just have any reminder program. You have to think carefully and be thoughtful about how you set up your reminder program. So we see some courts that spend a lot of time and effort and a lot of money to set up reminder programs, but then they don't see a lot of impact. So there's a couple of things that could be going on there. First, they might not be using effective content in their reminders. So here's an example. This is a real text message sent by a real court. I won't say which one. But if you receive this text message, would you feel totally certain of what you should do? See if you know, head nods. So yeah, maybe the information's not clear. It could also be because not very many people are receiving the reminders. So these numbers are from Colorado, which we'll get into more in a second. To give one more example, the state of Florida has a reminder program called e-Notify. It has about 45,000 users, so that's a good number of people, right? But it's probably about 5% of what the participation could be once you take into account the population of the state and how many people are involved with the court system. So there's a lot of things that get in the way of people signing up. We've talked to some courts that require people to sign up in person, some courts that require people to sign up via online forms where they have to enter a bunch of information. And if you get one number, one little thing wrong, the registration won't go through. So these things can get in the way of participation. So as they say, the devil's in the details. So we're going to walk through the details and all the key components of what actually makes a reminder program work. So we'll start with enrollment, which sometimes is an overlooked piece of the process, but is potentially, arguably, the most important part of the process, because a reminder program that doesn't enroll very many people is not going to have a lot of impact. We're looking for that broad reach. All right, so there's two ways you can sign people up for reminders. You can ask them to sign up themselves. We just talked about some of the ways that courts do that, or you can automatically sign them up as soon as the court has their contact information. So you can probably guess from the headline what we think is most effective. So we recommend automatic enrollment. That is a great way to get people into your program. But despite this, a lot of courts still require people to sign up. The problem with that is that there's drop-off at multiple points in the process. So first, people have to know about the program. And courts often spend a lot of time and money promoting the program. And yet when we talk to people, we find still a lot of people aren't even aware that it exists. People also have to know how helpful a reminder would be to them and be motivated enough to go out of their way to sign up. And then finally, they have to get through the sign-up process, which, as we talked about, can be challenging. So all of these things get in the way. Automatic enrollment helps address all of these barriers. All right, so here we are back with Colorado. So you saw the first part of this graph before. Colorado actually passed legislation to create a statewide reminder program. They initially asked people to sign up for the program, and luckily they were tracking their enrollment. They saw that the numbers were pretty low. So they actually changed the legislation to switch from requiring people to sign up to automatically enrolling people. And you can probably guess right about when they did that. So right here, there's a big jump. Participation quadrupled basically overnight. And you can see after that point, the numbers, they actually go up a little bit. You're not seeing a bunch of people unsubscribing and numbers going back down. So this increase that they saw actually led to a 34% decrease in missed court dates. And important to note that they did allow people to opt out. So once people were signed up, they got a welcome message. It gave them the option to say, stop, don't contact me. But very few people did. And the vast majority of people who did opt out, it was because it was actually the wrong number. So they were not reaching the right person. So that kind of shows that even though people didn't go out of their way to sign up for the reminders, they did want them once they received them. All right, so a lot of places do automatically enroll people, including Colorado and Texas at the state level, and a lot of places on the local level as well. But a lot of courts ask questions about the Telephone Consumer Protection Act, or the TCPA. So this is a federal law that regulates calls and text messages, and the goal is to protect the public from spam. The good news is we don't think that the TCPA applies to court text messages, and there's a couple reasons for that. So first, the TCPA prohibits calls made with automatic dialing systems or random number generators. You might have heard these known as robocalls. But courts don't send text messages using those tools. They are sent to known numbers that are associated with specific individuals. The TCPA also doesn't apply if the recipient has provided express consent to receive a message. And the case law around the TCPA has actually established that express consent can be satisfied by the person providing their phone number in a related context. So if they give their phone number at a traffic stop or when they're in court, then they can be communicated to about that case. So we know this one is tricky. We've done a lot of legal analysis on this, so we're happy to share that with you all. If anyone, wants to talk to us, bring your team to us, we're happy to talk always about this. All right. So we're all about auto-enrollment, but before you can auto-enroll people, you have to get their contact information. And the earlier you get the contact information, the more impact you can have. So there's a couple touch points, opportunities to collect contact information before the first hearing. The most common ones are at jail when someone's booked and released, or on the citation. So of course, courts are not traditionally involved in either of these steps, so it requires working with jails and law enforcement to collect phone numbers. Sometimes we hear that, courts saying they think these stakeholders will be reluctant to engage or to add something to their workload, but we've had a lot of success working with these stakeholders once they understand the impact that missed court dates are having on them, leading to increased warrants, increased arrest, and keeping them from doing the work they really want to be doing. So there's a couple different ways you can work with police and jails on this. So first, you can look at the release or bond forms given at the jail or the citation and see if it has a field for a phone number. If it doesn't, then figure out who's in charge of that form and go talk to them. And you might be able to convince them to add the phone number field, which we've been able to do in a lot of places. Second, even if the phone number field is on the form, make sure that they're actually consistently collecting the phone number. We know, a lot of these interactions, they happen quickly. They're tense environments, so they're not always collecting all that information. But if they're not, you can work with police and law enforcement to increase training so that officers know how important this is and how it benefits them as well. The goal is for officers to always ask for the phone number, but not to require people to provide it. But officers can increase people's likelihood of providing the phone number if they tell them that it's for reminders and that it's intended to help them. And then finally, once that contact information is collected, you also need to figure out how is that contact information going to get to the court. All right, so why is this so important? Why is it so important to do this so early? So in a lot of places, we find that the first court date is the most missed. And if you don't get someone's contact information and send them a reminder before that first court date, then you've already missed the opportunity to help those folks get to court. All right. And even though those first touch points are the most important because they're before the first hearing, courts should also take advantage of every opportunity you have to, when you interact with someone, to make sure their contact information is up to date, and also to ask them and give them another opportunity to provide it if they haven't done so already. All right, so now I'm gonna hand it over to Marshall.
All right, so our statewide system is an opt-in system. So anybody that has a case that gets filed is automatically in for messages, right? Opt-in, opt-out, it's backwards. I always screw that up. I'm sorry, it's an opt-out system. So everybody's already automatically opted in. With the pretrial clients that we've got, each one of them, for the most part, has been released from jail within the last 24 hours and has come in to see us. And we're meeting with them either by phone or in person. And so we're having a great interaction with that person. We're trying to build trust. We're trying to help these folks through service referrals. And one of the things that we can talk to them about is like, hey, we want to send you some text messages. Would that be all right? We want to let you know when court is. We want to let you know when to come see us, when to call us. If you miss that appointment, we're going to let you know so that you can get back with us so that we don't have to ask for a warrant for your arrest because we don't want to see you back in custody. And so really being able to explain the campaign is one of the reasons why we run an opt-in model and we ask for consent from all of our pretrial clients. When we initially created the program, everything that you heard at NAPSA conferences was that individual programs had their entire text messaging campaign shut down because they got in trouble with the text message police. The FCC came to get them. So we wanted to build a program that didn't work off of that. And so we started collecting consent from everybody that we were already having in-person contact with to begin with. Which is why we continue to use verbal consent or written consent. Once we have those messages, or once we have that consent, we can start sending them welcome messages and really explaining our text message campaign. Now, why does that matter? If you get over 3% of your phone numbers opt out, all of your telecom providers will then throttle you down. So on any given day, I'm sending somewhere between 1,500 and 2,000 text messages. If I get throttled down, I'm not sending them all at 8 o'clock. They'll have the opportunity to get timed out. But by having consent, by being able to explain my campaign, by being able to provide an affidavit to all the telecom providers that we only operate off of consent, we're able to send massive amounts of text messages and be able to do that on a consistent basis without being throttled down. Everybody enjoyed our wind yesterday, right? So courts close. And so if I have a number of courts closing, my numbers will go from 1,500 messages to 4,000 or 5,000 messages that day by the time we notify all the pretrial clients within certain jurisdictions. So it really is important to keep our numbers up so that we can get those messages out as quickly as possible. I don't know if a whole bunch of people drove here, but New Mexico's pretty big, and most of our jurisdictions are 2 to 3 counties, and those 2 to 3 counties are hundreds and hundreds and hundreds of thousands of miles, and so we don't want people driving from one side of one county all the way into the urban populous area to provide a UA if nobody's there to collect it. So we really, that's one of the main drivers as to why we run a program based on consent. Let's see, did I miss any of my points? I can also share that the information coming from jails just isn't getting shared across agencies and across platforms. We've tried to combat that problem through APIs and whatnot, working with jails. We've gotten a lot of pushback from jail legal divisions. Not sure exactly why, but they don't want to share their data. And the phone numbers that are coming into the court system just are generally stale because they're coming in off of traffic tickets. In 2014, there was a giant data conversion to a new records management system, which ported in a whole bunch of phone numbers. So if something's getting listed incorrectly, we're not going to be able to successfully get a text message to them. And I had a question. What is the name of your program? Of the provider that I use? eCourt Date, and they're fantastic.
Second question is, when you're doing your intake for the folks that are getting arrested, are you asking if they have any additional cases that you would remind them? The reason I ask is, so, for example, if someone's got a domestic battery, maybe they have a restraining order case, maybe they have a divorce case, maybe they have a child support case. 2 of those which could result in them getting arrested if not attending. They have child support, there might be a issue. So is it a combination or is it just a criminal?
Sure. So the question is in reference to if we have a defendant that's coming to pretrial services and they have multiple cases, but not necessarily cases where the pretrial program would have jurisdiction in, are we making notifications for those cases as well? Answer is kind of mixed on that. Yes, the pretrial officer at every office visit should be going into our records management system, looking for court dates, looking for new cases, looking for restraining orders, looking for anything new that may have happened within the court system between their office visits, and providing that information to that person. We do have folks that are only getting text messages, so they would not necessarily benefit from that. It's long as if it wasn't a criminal case, right? Because everybody's getting at least court hearing notifications for criminal cases, whether the pretrial program has jurisdiction or not. Yes.
And the reason I ask is like competency proceedings.
Mm-hmm.
To meet with evaluators. It's not really a court hearing because we court over evaluation and appointment with the doctor.
Okay. So Yes. So the question was, how customizable are your text messages, and how does that also apply to like competency, which isn't necessarily a criminal case? We can send text messages that say anything, and if Google can translate it, we can translate it. So that's the answer to question number one. Question number two is a giant change in the New Mexico court system, in that our competency now is, it does carry like a criminal component to it. And so because we can enter it into our records management system as a criminal case now, we can send text messages for it. So our pretrial programs, it's actually something that we're working through with our pretrial executives network, is how to get those into the system so that we can make sure to maintain court hearing reminders and necessary reminders. We have a couple of programs that are utilizing our vendor with one-off messages to remind folks for their competency hearings and evaluations. Any other questions? Yes.
Do you have a sense of how many, or like what percentage of people do not have cell phones, so that they can have received text messages, and what, are there any ideas for contacting those people, or how you might think about or go about like contacting those people, or people who just decide I don't want to give you my phone number?
Sure. So what we saw up there was that about 55% of our folks don't give us a phone number, or opt out, or don't have a phone to give us.
And as far as the folks who have a cell phone number, Pew Research actually asked that question very recently, and 97% of U.S. adults have a cell phone that is capable of receiving and sending text messages. So we don't actually see that as much of a problem. There are court reminder programs that function with email. However, the reason why we don't, which we'll get into many of these questions in just a few minutes.
Even snail mail. There's
Yeah.
lots of different options, and even you can have a combination of options, right? Depending, so that you can reach everyone regardless of what type of contact information they provide.
And we'll talk about the email. I was going to say that we don't recommend them necessarily, but.
Next session. Are you ready? We're good. All right. Okay, so thank you. Many of those questions are great setup for the next couple sections. So the next thing we're going to talk about is how you can set up your reminder program. All right, so when it comes to delivery methods, you do have options. So we've got text message, but we also have email. You have traditional mailed notices. You can make direct phone calls. Which one is best for your courts will depend on what's feasible for your courts and what kind of contact information you have access to. But in many courts, the best case scenario will be a combination of methods, so that you can reach folks regardless of what type of contact information you have. Even, mail might seem a little more old school, but we worked with Sacramento County, California, to introduce a mailed reminder because that was what was available to them at the time. And we saw an impact there, a significant increase in court appearance. So if that's what's available to you, go for it. Any reminder is better than no reminder, right? But overall, we recommend text messages because they tend to have the most pros, the fewest cons, and phone numbers tend to be easier to collect, especially if you're talking about collecting with a roadside stop, right? Like trying to get all the letters of someone's email address there's often a lot of typos, phone number can be a lot more straightforward there. But you've got options. All right. Next question is, who should send the reminders? So the best case scenario is a statewide program where the state provides and pays for the reminder program that's available to all courts in the state. If the courts in that state are on same CMS, that makes this easy. The state already has access to the court's data. They're all operating on the same system. But even if courts don't use the same CMS, the state can still provide a reminder program through a vendor like eCourtDate that can work with all the different CMS systems in the courts within that state. And that's what Texas is doing, actually. Even if there's no state level program, you can still do this at a more local level. And we encourage you to do it even, as you work towards hopefully convincing your states to do it at the state level. One thing to note here is that a lot of existing reminder programs are sent through pretrial agencies or through public defenders. And we are big fans of these programs, but it's important to recognize that they don't reach everyone. And often they're leaving out some of the critical populations, like folks with low-level offenses who are often most likely to miss court, folks who are earlier in the process who might not have been assigned counsel yet, for example. So we definitely support these programs, but think they should be supplemented so that everyone in the state can get reminders, which is just what New Mexico is doing. All right, so looking at different reminder platforms, so the technology behind reminders. There's a couple of different options here. So just to give you an overview, first is what we call turnkey. So this is where your existing CMS may have reminders as a feature that's built into the CMS. This may already just be available to you. You might have to sort of tell them to turn on this feature for an additional cost, but it's available through your existing CMS. The next option is DIY. So your court IT team can actually build a reminder system for you, especially if you want a lot of that customization. That's something you can do. It's typically done by connecting your CMS to a reminder provider like Twilio. And then finally, we have specialty communications platforms. eCourtDate, which New Mexico uses, is one of those. So those are vendors that specialize in court messages. And they provide full service support. So they'll help you set up your reminder program, they'll help you manage the reminder program, and customize it to whatever your court's needs are. So, of course, when you're thinking about which one to choose, there's always trade-offs, like everything in life. So first, looking at the flexibility, you have to decide what content can be included in your reminder. Typically, the turnkey options, the reminders that are built into your CMS, will have pretty low flexibility. So they might have rigid requirements, they might have existing templates that you have to use that language. They're not particularly customizable, typically, although we're always open to being surprised. DIY and specialty comms platforms are going to be really flexible. You can typically choose what kind of content you want in the reminders. You can also tailor reminders to specific use cases. So you could have different content for civil versus criminal. You could have different content if it's a virtual hearing versus an in-person hearing. Whatever use case you want to send a text message for, you can create all those different categories. Next, looking at effort for courts. So the turnkey options are typically the most straightforward. It's already built into your existing CMS. Just ask them to turn it on. Sometimes easier said than done, but still typically the most straightforward option. DIY is the heaviest lift for courts because the court is actually building it themselves. So it's taking up, the IT resources to build that. And specialty comms platforms are somewhere in the middle because you don't need to build it yourself. You don't need to use all that technical staff, but you do still need to dedicate staff time to working with the vendor so that you can customize the platform to exactly what you want to do with it. And they all come with costs. But across the board, the cost of reminders works out to be about $1 per case or even less. And as we've covered, that's helping you prevent missed court dates, which come with a lot of costs. So $2,850 is the total price tag. That's $1,500 for the government plus a dollar figure that we put on the cost to folks who miss court. To put that another way, if you want to set up a reminder system that covers 10,000 cases a year, the estimates that we've seen from vendors show that it's going to cost you at $8,000 to $16,000 to do that. But it helps you avoid millions of dollars in costs, including $1.75 million directly to the government. All right, so yeah, saves you money. All right, so now I'm going to hand it over back to Marshall if you want to share anything more about your setup. All right, Marshall is on it. He's already covered all his points. All right. So last piece, finally get to look at the content. What are your text messages or your reminders in general actually going to say? All right. So we're going to cover some key elements that you can include in your reminders to make them more effective. So first, it's really important to clearly state the consequences of non-appearance or non-compliance. For most people, going to court involves trade-offs, right? Like they might have to miss work, they might have to find childcare, and these costs can be significant for people, and they're also felt immediately. So they're going to be really top of mind when someone's thinking about how they're going to get to court. The costs of missing court might feel farther down the road. They might feel more abstract, or people might not even know what the consequences are. So making it really clear can help counteract that problem. And one aspect of that is to not use a bunch of jargon or overly technical language. So Isabel mentioned capious earlier. So use warrant, a word that most people will understand instead of terms that are only understandable to courts. Next, you can encourage people to make a plan to get to court. And we've actually tested this and rigorously evaluated it, and this combination of consequences and plan making was the most effective combination that we tested. That helps people think concretely, right, about what barriers they're facing, what they need to do logistically to make it happen. Provide all the information they need to navigate the process, and also offer help. Let them know that the court is available to answer questions, to help them navigate the process. All of these things are the difference between a reminder program that just kind of checks the box of saying like, okay, we told them they have a court date and that's the end, versus a program that actually addresses all of the challenges that people are facing. And it not only helps people feel confident that they can navigate this process, it also increases trust and confidence in the court. So talking about rule of law, and we'll get to that later too. But this is a huge way that you can kind of build up that confidence. All right, if I could get this thing to cooperate, there we go. Okay, so here's an example of how all these elements come together in a reminder. So this is a series of 3 text messages sent before a court date. So I'll click through. There's a couple of elements here. Hopefully you can see the little green lines highlighting them. But first, we start with someone's first name. So this catches their attention and also makes clear to them that this is something specific to them. It's not spam. We emphasize the consequences of not appearing. So it says show up to avoid arrest warrant. We provide logistical information they need to get themselves to court, prompt them to make a plan. You can also address fear. Isabel mentioned folks might be feeling fear or apprehension, uncertainty about what's going to happen at court. So in this case, that we're able to say that a public defender will be available to help. And then also offering resources. So if people have questions, they know where they can call to get the answers. All right. So it's also really important to send notifications after somebody misses court. Often people have a very small window of time to address the missed appearance before a warrant issues. So it's important to, one, let them know they missed court because people don't always realize, and also let them know what the process is to address that and avoid a warrant. And if a warrant does issue, it's also important to let people know and, again, provide clear instructions for what they can do to remedy that. All right, so how many reminders should you send and when? The answer depends on what delivery method you're using. So for text messages, as you saw in the example, ideal is to send 3. That way you can fit in lots of different types of those different elements in the content. If you send it 7, 3, and 1 days before, that gives it early enough that they can start to make a plan, but also reminds them right before so they don't forget. Email, we recommend a similar approach, but starting a little farther out because people typically are slower to open emails. Oops. For mail, typically we see courts only sending one mail reminder because of the additional cost with postage, and that should be sent with 14 days before, again, because it takes time for mail to reach people and get opened. And phone calls, you only need to reach someone once, but it might take 3 or more tries to get a hold of them. So starting at least a week in advance helps there. And phone calls can be more labor intensive, so may not be an option for everyone. But these are different considerations for timing. All
Do
right.
you have a question?
Oh, yes, please.
Was there like an overall agreement that you guys could just unilaterally give them a monthly schedule? Like, how did that come to be versus, and is it all cases or only maybe low-lying fruit cases that aren't really big or, more serious? How did that come to be?
Yeah, so that will depend on the court and what the process is in that jurisdiction. So we work with places, we do recommend grace periods. We think giving people time to resolve their missed court date before warrant issues is obviously beneficial to them, but also beneficial to the court. We work in places like Georgia, does offer a 30-day grace period. But we also work in places that don't do that. Even if you don't have a grace period, you still want to encourage folks to know that they miss court, know that a warrant might issue, and give them a clear process that they can follow to address that, so that it isn't that their only option is just to have the warrant served and have that process play out. So it'll depend. Yeah. All right, so last thing I'll say here, as I'm sure you all know from working in courts, is that there is no one size fits all. Every court is different. So the content, the timing, that'll depend on the needs and the process in your court. But no matter what, we recommend that any reminder program follow a couple basic principles. So automatic enrollment, sending reminders before every hearing and after missed hearings, and using proven behavioral content. So now I'll hand it over to you, Marshall, to show how this, our sort of best practice content was adapted for New Mexico.
Sure. So our messages are going to look exactly like what Ann set up in her piece, because, well, we used Ideas 42 to create them about 6 months into the text messaging program. We have multiple defendants that'll use the same phone. So we've got a set up for that. So all of our messages are geared to being case specific and individual specific. And then I think beyond just court hearing reminders, are these still reminders? Yes. But beyond court hearing reminders, we're sending, like I said, court cancellations. So we don't want people to go through the hassle of taking off work, getting babysitters, spending all day on a bus system to make a 3 p.m. court hearing if it's canceled. So to avoid some frustration, we're going to send them that. We send them a welcome message the day after they come in for their initial intake appointment. And we should be telling them, hey, save that number to your phone. It's the best way to, make sure that you're getting messages and you know who it's coming from. And then, like I said, we send failure to appear messages to follow up with them. We're also sending messages for office visits and remote visits. And like I said, anytime the court's closed or delayed. And one of the cool things with eCourt Date, we were able to go through and pull the top 10 languages in New Mexico and send them through our language access services group. And they translated all of our messages into 10 different languages. And so on the screen is a message in Diné or Navajo. And so because we do have Navajo Nation as part of New Mexico, we wanted to make sure that we're reaching out to that community as well and getting them timely messages. So
very quickly before we wrap up, we just wanted to tie this back to the theme of this conference, which is the rule of law. It may not be the most direct association between court reminders and the rule of law, but it's actually really important because the rule of law depends on a very simple idea that people can meaningfully engage with the justice system. And text message reminders, email reminders, any kind of court reminders, makes it so that you avoid one of the biggest barriers to folks meaningfully participating, which is missing a court date. In addition, when courts send reminders, they reinforce the idea that the justice system is something that they can navigate. It empowers folks to be a part of their defense, their participation in the justice system, rather than to feel as though the justice system is something that is set up to trip them up, that is alienating, that isolates them from the system in general. And it feeds into public trust in institutions. Reminders also reduce unnecessary warrants and jail bookings, which protects the legitimacy of the courts. When folks are arrested, let's say for missing a hearing in an ordinance violation case where they were cited for driving without insurance, that erodes public trust in our courts as institutions, and thereby erodes the rule of law generally. And finally, reminders improve consistency. They help courts treat all people equally under the law, which is a core tenet of the rule of law. So just to close out, court text message reminders are a small operational change that has huge institutional impact and huge ripple effects throughout our justice system, from the courts to the jails to general trust in our institutions. So thank you so much for letting us present today. Anne's going to tell you about a couple other resources that are available to you before we open it up for questions.
So quickly, I know we threw a lot of information at you today, but knowledge is power. So hopefully you all now feel like you have the power to go back to your courts and advocate to do what our doctors and hairstylists and others have been doing for years, because it works. And the resources don't stop here. So we have a guide called the Essential Guide to Court Reminders. It's online. I'm also happy to send it directly to you. It has all this information and more. There's also information on our website, on Pew's. And please don't hesitate to contact us anytime. We do this work for free to courts. We are always eager to talk about this topic and help you in any way we can. So please don't be shy. And I know we sort of did our Q&A within the presentation, but we are also happy to stick around for anyone who has a little more time and wants to ask some more questions. You've got us now too. So yeah, tell us how we can help or where you want to dig in more.
Yeah.
I just wanted to mention too, text reminders also work for payments that are due.
Yes, for sure. So for anyone who didn't hear, he said that text message reminders have also cut down failure to pay warrants by 40% in New Mexico. It's an incredibly powerful compliance tool across the board. If you want folks to participate, to do anything that has to do with the courts, I just received a text message about a bill due for my internet provider while we were presenting today. And that's how I, remember to pay that bill. So great point. Thank you.
And we're selecting current. Do you also send reminders to the other ones that are still listed, or just the one that we're highlighting as current?
Only the number listed as the current cell phone. That's it.
Last one.
So you mentioned that you get responses to your text messages. So I'm wondering what your approach is for handling the responses so it doesn't become a burden.
For the pretrial program, we have automated messages that go back that we're not monitoring any incoming messages. When I have time, will return emails. I'll forward emails that we get back to the individual pretrial programs. I try about 2 to 3 times a week to go through and review all the inbound messages. And if they're pertinent to court dates or they need follow-up, I'll send those messages to the assigned officer for follow-up.
And different courts handle that differently. So some courts it's a one-way, they actually won't receive the response. So then there'll be typically an automated response that says, this message is, we can't receive responses, but you can contact the court by XYZ. So making sure there is a place that they can go to share that.
I think we're at time. If anybody has other questions that they want to come and chat with us about, we're hanging out for a minute, but we want to make sure that you're able to make it to.
And I have notebooks and pens
Yeah.
and stress balls, and you're
Yeah.
all welcome to them.
Yeah. Thank you all so much.